Hi, everyone. This is Michael Misko with Misko Health Law with the third installment of our presentation series on responding to record requests. In part one and part two, we talked about some HIPAA considerations. We've talked about various types of written requests, as well as on-site requests by law enforcement pursuant to a warrant, and the basics of how you're going to react to that. In this final installment, we're going to get into a little bit more detail about putting your record package together in a scenario where you have an obligation to disclose records. And I'm focusing more in this scenario on commercial payer requests for records as part of a post-payment audit. Now, as a starting point, understand that they don't do these audits randomly. Okay, so they don't throw darts at a wall, or they don't draw a number and then go into their provider database with everybody in alphabetical order and say, hey, it's your turn to be audited. It's not how it happens. In today's environment, and for about the past 10 years, data analytics are used to identify billing patterns that are suggestive of potential overpayments. Understand that now they have AI assisting this analytical effort such that payers can be much more timely in identifying aberrant billing trends, such that I anticipate that, especially because of look-back laws, which are restrictions on how far back a payer can go, absent fraud, waste, and abuse, that payers are going to be a lot more timely in identifying problems, which, is bad from the standpoint that there might be more audits. It's good because it will limit the scope of the overpayment period potentially, and give you an opportunity to enact corrective action more timely, such that we're not talking about several years worth of an issue, and therefore a very large amount of money. So, in other presentations, we talked about some of the common things that payers look for. Just to quickly review, certain code pairs: manipulation and manual therapy. You're just begging to get audited. Manipulation and extremity manipulation all the time, or a very high percentage of the time. Again, begging to get audited. Doing both, begging to get audited. Too many E&Ms, evaluation management services, 99212 through 205, especially the reevals, 212 through 215. That is, something that payers look for. Too many services on a visit, visit frequency less than one visit per week on average, when they calculate it per patient. Those are indicative of maintenance or palliative care. So just understand there's a bunch of ways that they look at data. Number of visits based upon your diagnosis. So if you're diagnosing a symptom and subluxation or joint dysfunction, understand that when you're going, it makes your care look palliative, so that would be absolutely somebody I'd want to audit. But especially when you're trying to justify 10, 20 visits for neck pain, it just doesn't appear rational, where maybe the patient really has, a facet syndrome and cervical neuritis radiculitis, then maybe it makes more sense. So those are things that payers look for. But when you get tapped and it becomes either necessary or it's deemed to be prudent to go ahead and submit the records, we have to think about how we're going to put this together. And you'll recall we have a minimum necessary disclosure requirement, but that doesn't necessarily mean that we're only going to disclose what they're asking for. Let's say we determine that correct coding and medical necessity are issues that the payer is concerned about, or more general terms, policy compliance. And that means every issue is on the table. So even if they're asking for a single visit, we are potentially going to disclose a lot more than that single visit. And the reason is this: if medical necessity is on the table and I pull a visit out of the middle of a plan of care, under the premise that you're actually on a plan of care, and hopefully you are. It's like trying to read, a page out of the middle of a book and then being expected to understand what the book is about. It just can't be done. So we're going to go backwards to the initial evaluation for the problems addressed on that date. We're going to pick up interim evaluations, which hopefully demonstrate progress, so that we can put this one visit that they're interested in the context of these other visits. And get assistance with analysis. Once you get your records together, it's a good idea to have them reviewed by an expert ahead of time, to point out any obvious things, especially if that expert has experience with that particular payer, things that that they're looking for, whether it's part of the policy or not, and to the extent that any supplementation through addendum, properly constructed, of course, meaning it'll be dated as of the date that addendum was created. We will explain why we are creating this addendum and what additional information that we want the payer to consider. And the reason that that's important is that in my experience in doing this for as long as I have, once a payer comes up with a determination based upon whatever you submitted, it is very, very difficult to get them to change that opinion through submission of additional information. Sometimes it's like trying to move a mountain. And oftentimes I tease, the investigators on the other side. I said, come on, you're giving me the please don't confuse me with the facts defense. Here, the objective in this analysis is to determine whether the payer paid for something they weren't supposed to pay for, not to raise hyper-technical objections about documentation content or whatever. I mean, hopefully the objective is to achieve some equitable result. And no doubt there are some things when they audit you that you're likely on the hook for and that you're going to have to refund. But there may be other things that are explainable and or justified in the record, or they're applying a standard that they don't have. It's what I call the everybody knows rule. But having some assistance during the record preparation process is oftentimes critical to how this process is going to resolve. I did mention keeping a copy of what is submitted so that if there's any question about, and even to the point where you Bates number the pages so that they can't argue, oh, we didn't get that record. Well, yeah, you did. It's Bates number whatever, and here's the submission that we sent you. And it eliminates those kind of problems as you work towards resolution of whatever the payer's upfront concerns are, what concerns they develop after they've looked at the records, and helps to get resolution. The other reason why you want records evaluated before they're submitted is that if there are, in fact, issues of policy compliance that we can identify, we implement corrective action immediately. Okay? Now, some doctors are concerned that, well, shoot, if I do corrective action and I make these changes, isn't that admitting that I was wrong? And it might be, but it doesn't matter, because if you were out of compliance with a particular policy requirement in a manner that justified an overpayment, it's just a civil administrative overpayment issue. It's not a fraud case, so we're not worried about intent or did you know about those aren't issues that are of concern. It's not about being dishonest or anything like that. It's just you made a mistake. You were supposed to do something, you didn't do it, and maybe that justifies the payer demanding a refund. That being said, you want to implement corrective action right away, A, so that you don't have that liability going forward, and B, because oftentimes the resolution of these post-payment results, it takes a little bit of time, but they, in evaluating a settlement proposal, they look to see, what has changed in the data relative to your billing, and to the extent that they see positive change, that helps in the settlement process. Because a lot of audits, most payers, It's not just a hunt for money, but they're looking to eliminate payment vulnerabilities, and they're more concerned about what's going to happen to them in the future than what has happened in the past. When a payer asks for a great gob of money that they know that you don't have, they know they're not going to get it. And, so there's going to be some settlement that, might sting, but it's going to allow you to survive. And, generally, I don't recommend self-help, and here's why. There's an appeal process, okay? And when you file some incomplete appeal, you've burned a step. And it's very difficult sometimes to convince a payer to allow us to restart that process and do it the right way, and you may get stuck going, filing your first substantive appeal in arbitration, which is expensive, and it raises the potential, like, you didn't raise this defense before, you've waived it. So you compromise your legal rights, when you try to handle these things yourself. And I've never seen a scenario, except for one, where a provider had the knowledge to effectively appeal on their own. Usually it turns out to be a disaster. So recognize that you do what you do, and there's people that do this, and you're not one of them. So get assistance when you get buried in this process, because with assistance, you have a better shot at getting a better result. One last thing about law enforcement, from a policy perspective, arrange in advance. Every practice should have a healthcare lawyer, and not necessarily a criminal defense team, but you should have somebody that is an external compliance contact, legal, that you can contact in the event that somebody shows up with a search warrant, you get a civil investigative demand, because time is of the essence in those scenarios. So you need to know, and your staff needs to know, who's going to be, who that person is, what their phone number is, how to get a hold of them in the event of an emergent need. Additionally, staff training, everybody should know how we're handling record requests. Somebody shows up at your office, you need to know who the point person is going to be. And one last point about that I forgot to cover with an in-person request is that when somebody shows up from an office saying they're from XYZ insurance company, demand credentials, find out who their supervisor is, call them, and make sure that they are who they say they are, and that they are within their work responsibility being there. And I say this because I had a case where somebody who was an investigator in an insurance company went to a doctor's office, not for a legitimate corporate purpose, but to get records for a spouse, because they were involved in divorce proceedings. So, just, make sure, think of red flag rules when you used to have to make sure that the patient that presented you was actually that person. You want to validate that that person is who they say they are, that they have a legitimate purpose for being there. And if it's not convenient for you to deal with them if they show up unannounced, you can tell them to leave and come back to when you're not going to have patients, and you can, deal with them. When that visit does happen, sometimes they will request access to your EMR program. That absolutely is not happening, okay? If you understand the HIPAA security rules, you would know why that's not going to happen, but they do not have access or any reason to access any record other than, beneficiaries of their particular plan, and even then, only the records for services that were billed to that plan. So if they show up on site, you say, look, have a nice, comfortable seat in the waiting room. Give me a list of what you want. We will prepare it. We will hand it to you. If you don't want to wait, we'll mail it to you. And that's also, a good time to get your compliance contact or compliance counsel on the phone, to have a discussion with them to say, look, we're not going to alter records. We understand the drill, but, you're just not accessing our EMR program and printing out records with reckless abandon. It's just not happening. Even in the case of, like, I've seen a scenario where a board investigator thought that they were going to take a magical mystery tour through a provider's file room. No, you're not. Fourth Amendment, they can request specific, records, the board can, and you're obligated to produce those records, but nothing more. They would have to have probable cause, to request additional records, and if they need additional records, they'll request them. So hopefully that gives you some thought processes around these requests, how to address them, and think about how you're going to implement policies so that everybody understands, so we don't make a mistake and errantly disclose in a scenario where you're either not required to or where such a disclosure would be a violation of HIPAA. Okay? So that's all we have time for. I hope that was helpful, and we will see you next time.